The Arizona Supreme Court recently ruled that state lawmakers can go ahead with their lawsuit against Proposition 211, known as the Voters' Right to Know Act, which targeted dark money in elections and was passed by an overwhelming majority of voters in 2022. The lawsuit claims that Prop 211 improperly delegates legislative power away from lawmakers. Attorney Robert McWhirter joins us now to help explain the court's ruling. Robert, good to have you here.
Hi, Ted.
Good to see you again. All right, so what exactly did the court do here? Because this deals with standing mostly, right?
Standing. Okay, we're in the constitutional weeds here.
Yes.
I mean, most people don't wake up in the morning and say, I'm worried about standing in the Supreme Court. What standing is, it's a doctrine nationally, really, in the federal Supreme Court, that says that, are you the right person to bring this? Do you have an injury? Do you have standing to complain? Now, in the Arizona Constitution, you actually don't have prohibitions against standing, but they kind of have an equivalent. It's the court's prudence they will do it, because the U.S. Constitution has specific things about that, and the Arizona Constitution doesn't. So they had an easier hurdle to get over to say they have standing.
And basically the lawmakers are saying we have standing because this voter-approved law, and I'm going to ask about this, because if this voter-approved law takes away legislative power, I would imagine all voter, but they're saying that this voter-approved law takes away our power as lawmakers to make laws.
Yeah, and what the court said is, we're really not going to get to that issue. We're just going to let you be the one to complain about it. So we're not going to hear in other words, we'll hear your complaint later, but right now we're just giving you the standing. Now, you just said something very important, and that is, okay, what do the voters have versus what the legislators have? And in Arizona, unlike nationally, voters are legislators because we can do initiatives and referendums. Now, you don't have that in the federal Constitution. Certain states have that, and Arizona is one of them.
Right. And the law and the legislature forever has hated that.
They hate that because they think they should be the only ones doing it.
But Robert, if this case, if the Supreme Court says, yes, you do have standing here because this takes away this, it's possible you could be harmed. And I don't understand exactly how they would be harmed, and I don't understand the possibility of that. But if that's the case with this voter-approved ballot measure, what's with all the other ones?
Okay, with the other ones you got to put in two camps. There are the voter initiatives that change the Constitution. But as you stated, this is the Voter Right to Know Act,
yes,
which is like a statute. Now, what acts do, and this is what the dissent in the opinion said, is what acts do is they often give agencies, executive agencies, power to create rules and regulations. And there's always this constitutional question, are you making a rule or are you just legislating for us? Now, this is big in the U.S. Supreme Court with what's called overturning the Chevron doctrine, okay, but that's federally. So this is at play here. So what they're saying is, look, this power they're giving to the Independent Redistricting Commission is giving legislative power, not just rulemaking authority. And we want to be the ones to complain about it.
It's clean elections, though, correct?
I beg your pardon.
Yeah, clean elections.
I beg your pardon. Yeah.
So they're basically saying that you're letting them do what we're supposed to do.
What we're supposed to do. Now, the interesting thing is in Arizona, you do have a history of division of power. Remember, we have a corporation commission, for instance, which is a fourth branch of government. Now, if they would have made this on that level, you could actually have an argument whether they created a fifth branch of government just on this issue. But it's still an act, and so they're arguing, no, you can't give them all this power to create regulations because you're actually legislating.
But Robert, this, correct me if I'm wrong, this basically reverses a trial court ruling. So
Yes.
what did the trial court find that was so different than the Supreme Court's looking
Well,
at?
what the trial court find is, I'm sorry, Speaker of the House and President of the Senate, you don't have standing. In other words, no harm has occurred here yet. And this is what the dissent said. They get into this little analogy of, okay, somebody gets your credit card, but until they use it, you haven't been harmed. Okay, in other words, somebody steals your card.
Right.
Until you use it. And so what the dissent is saying is, well, they haven't used the credit card yet. In other words, they haven't created the regulations, which may or may not be a violation of the power of the legislature to legislate. And then you have this issue about, well, what's the status of the voters as legislators and initiatives versus the legislators themselves? And the dissent is saying, hey, you're putting now the voters in kind of a second lower power tier, but they're not. They're supposed to be the same as legislators when you're using the initiative process.
Yes. And there's another. The Supreme Court is looking at this issue by another court case, and that involves free speech rights, correct?
Oh, yeah. Yeah, okay. So there's another thing. What regulations are you allowed to bring forth, and where's the constriction? And when does legislation begin and regulation begin? When does a regulation become legislation that the legislature should pass and there's a separation of powers? Because remember, what the legislature does is give delegated authority, both in Arizona and nationally, delegated authority to the executive to affect laws. So they're saying, okay, we can't make every little regulation about what the state mine inspector should do and what kind of copper ore he should look at. So we delegate that to an agency, an executive agency. Well, that's okay. But the issue is, when does that executive agency go so far that they're legislating something the legislature should do? This is the tension.
Does this, the fact that they say you have standing, and again, reversing the trial court decision, reversing that decision, you got standing, does that suggest that the state Supreme Court, when it does decide this case on merit, will decide this case in favor of lawmakers?
If I were the two parties here, I'd much rather be the lawmakers than the other ones challenging it. And you got to kind of look at the interesting politics here. It's the Republican legislators who don't like this initiative. And so they're fighting this standing battle. But the act is the Right to Know Act, the Citizens' Right to Know Act.
Right.
I guess they don't want the citizens to know where the money's coming from. I mean, it gets right down to that.
Yeah, it's a dark, it's
dark money.
It's anonymous speech,
Right.
and we have many programs on this and many shows
yes.
from those who are saying if you limit anonymous speech, you are limiting people's free speech rights, and you're chilling. Right. It has a chilling effect.
Well, former Justice Antonin Scalia on the U.S. Supreme Court, he was big in overturning Citizens United, the
yes.
campaign. But he did say, and he never had a case in his lifetime on this, he said, well, you should not put limits on free speech, not put limits on campaign contributions, and I kind of think that's wrong. But he also said, the First Amendment doesn't give you the right of anonymity. You're allowed to say whatever you want, but you're not allowed to be free from people who are pissed off at you for saying it.
Yes, and that is the delineation, and we
Right.
have had so many back and forths on that on this program. We're out of time right now, though. Good explanation, Robert. Good to see you again.
Thank you.